Good afternoon, everyone, and thanks for joining us in the Employment Law Q&A. My name is Lluc Cerda. I'm a senior associate at Samfiru, Tumarkin. I'm the managing associate of our Alberta office, and I'm here to take your questions today about anything and everything related to employment law. And if you have any questions, feel free, just put them in the chat. We'll get to as many of them as we can before the end of our show in half an hour. While we get started, I wanted to talk to you about something from our blog. We were blogging earlier this week about a case that came out of the Alberta Human Rights Commission, Human Rights Tribunal, rather, of a gentleman who was denied an accommodation at work, eventually terminated, and who was successful in having that termination ruled discriminatory. So this is something that's quite common in Alberta. The gentleman had been presented with a rotating shift where he would work days for 7 days, nights for 7 days, and then have 7 days off. And I often get calls from people, I'm being told I'm going on night shift. What can I do? In this case, the gentleman had a medical condition that made it hard for him to work nights. He had an acid reflux issue that would have been worsened by working in the evenings or working in the overnight, actually. The employer refused to accommodate him, and he was terminated. And so he went to the Human Rights Tribunal and was successful in having the tribunal recognize that that's a form of discrimination. If you have a medical disability that doesn't allow you to do certain parts of your job, then you are entitled to an accommodation up to the point of undue hardship. And that also applies to working overnight. The type of schedule that you have can be important. So an important thing to note, if you are someone who has or is going to have difficulties for any reason changing your shifts or another aspect of your employment, it's important that you reach out to us, reach out to a lawyer to discuss any accommodation rights that you might have prior to agreeing to the change. It's a lot harder to get an accommodation once you've agreed to the change, once you've worked successfully in a role. It's not impossible, of course. It depends on what your doctor is saying. But don't think that just because an employer is changing everyone's schedule or everyone's work conditions that you have to accept it as well. Every single worker is entitled to be free from discrimination and is entitled to be accommodated if they have medical restrictions in their employment up to the point of undue hardship. Now, in this case, the employer was not able to show that it would cause them undue hardship to accommodate the employee, and therefore the employee was found to have been discriminated against. There was a duty by the employer to accommodate, and they failed in that duty. So we have our first question from Lou on YouTube. It's Lou is non-vax, non-union. If the leave of absence is constructive dismissals in the eyes of the law, why won't the employer agree with me if I myself, without a lawyer, tell them that it's constructive dismissal and ask for pay and severance? The reality is, Lou, in my experience, although you can, in fact, represent yourself in court on your own, and you can represent yourself in negotiations with your employer, you're not taken as seriously when you don't have a lawyer up by your side. That's just the plain reality of it. It's not fair, but it's the way it is. In terms of constructive dismissals often start with the employer denying that they constructively dismissed you. They'll say, no, I cut your salary. I put you on a leave of absence. I required that you cut your hours. I did that. That's nothing. That's just a slight change to your working conditions. That doesn't amount to a constructive dismissal. And in fact, you'll find that a lot of trials and a lot of decisions related to constructive dismissal, the first step the judge has to undertake is to determine whether a constructive dismissal has occurred. So because of that, a lot of constructive dismissal cases sometimes go all the way to trial for determination if there was actually a constructive dismissal or not. So the employer, can, as a defense to your claim, say, well, I haven't constructively dismissed you at all. Go ahead and prove it. And once you've proved it, then we can talk. And so that's the problem you're coming up against, Lou, is that the employer is challenging you to prove that you've been constructively dismissed. So if you have, then you're entitled to severance, and that's great. But if you haven't, then the employer might not owe you anything. So that's why they're telling you, go ahead and prove it. I don't see a lot of risk right now, probably because you don't have a lawyer, and I'm not too concerned that I'll have to pay you severance. But if you're ready to fight for it, go after your severance. Then I strongly encourage you to reach out to us. We're happy to help. Discuss your case, see if we think it has merit, and if it does, to move it forward for you towards you getting you a severance package. All right, we're back. Sorry about that, everyone. I had a bit of a stormy weekend here in Calgary, and as some of you might realize, and I don't know if my internet is impacted as a result, but I'm back. All right, so we were speaking with Sports Hall. Amen to that. Thank you. Very good. I think Sports Hall was referring to my first comment regarding the night shifts. If you were not, or if you have a question, Sports Hall, feel free to just put that in the chat. We have a second question again from Facebook this time. This one's from Polly. I've been cleared to return to work after being on medical leave, but I'm being brought back to a lower position. My employer has said that after 1 year, my salary will be reduced because it's a lower position. Can they do this? So 2 points, Polly. So the first point is, if you're coming back from medical leave, the employer's first obligation is to check whether you can go back into the job that you had. And by that, I mean that is your job, are you able to do the job that you previously had? Now, you might say, well, I can, but with restrictions. If those restrictions can be accommodated to the point of undue hardship, then the employer's role is to put you back into the job that you had and provide you with an accommodation. It's only after the employer has determined, with the help of your doctor, that you cannot do the job that you had before because of your restrictions, and you either with or without accommodation, and that the employer has to look at another job. Okay. So the first, and this goes back to what I was saying before you accept the lower position, you want to reach out to us to make sure that your employer doesn't in fact have the obligation to place you in your previous position with accommodations. All right. So that should be the first option. It's only after that option has been exhausted and is found not to be feasible that they have to look at other positions. Now, if the scenario is that you can't do your old job even with an accommodation, there isn't a comparable job that they can place you in because they have no openings right now, and the only job they can offer you is a lower job, then it may be that yes, you have to accept a pay cut in that case. But as you saw, there's a lot of steps that need to happen first. I'm far from confident that your employer has done it right. In fact, in my experience, employers don't often get the accommodation process really well. And by accepting this lower position, you might be foreclosing the right for you to do your old job, the one that you were hired to do, with a very reasonable accommodation. So reach out to us. We want to hear more about, these are very fact specific, of course, the fact of your disability, of your restrictions, of the workplace you work in, all of that is fact specific. But reach out to us. You can reach out to us at employmentlawyer.ca. You have the URL on the screen there, employmentlawyer.ca. We'll be happy to chat with you, see if everything's been done right and how we can best help you get, that you're treated fairly at work. We have a follow-up from Polly. I have been cleared to return to work after being on medical leave, but I'm brought back to a lower position. It's the same question from Polly as before. Okay. We have a question here from Carrie Smith. Is there a difference between being laid off and being fired? My sister has been told that she's going to be placed on a layoff with no return date, and she is unsure what that means. Well, yes, there is a difference. Carrie, that's a great question. So, essentially, a layoff can mean that there's insufficient work for you, and you're laid off, and then you'll be recalled once there's enough work. Whereas a termination is just that. It's your job is terminated. It's not about how much work there is. We're not calling you back. You don't have a job anymore. Go find another job. A layoff is trying to preserve that employment link, saying, listen, you're going to be without work for a while, but eventually we're going to call you back. All right. So we've discussed on this show many times that the first time you're laid off, generally you don't have to accept the layoff. If you want to go after severance, you can. You can treat the layoff as a termination. However, some people like their job or for whatever reason are okay to be on layoff so long as they're called back at some point. All right. And if your sister is okay to do that, then that's fine. She's going to receive a record of employment. It's going to allow her to be on EI. And her employer hasn't officially terminated her, so doesn't officially owe her severance yet if she's okay with the layoff. At some point, the layoff will become a termination. Okay, so you can't be laid off forever and then never get your severance entitlements. At some point, the layoff will become a termination. In Alberta, it's after 60 days. In Ontario, it's after either 13 weeks, which is 3 months, or 35 weeks if the benefits are continued during the layoff period, which is 8 months. All right, so it could be a lengthy layoff, especially if you're in Ontario. So you definitely want to check whether she's been laid off before. If you've been laid off and then you get called back and you go back to work, it's as though you've accepted that you can be laid off because you've come back to work. You didn't protest the fact that you were laid off. But if you've never been laid off and there's nothing in your employment contract that says that the employer has the right to lay you off, you don't have to accept a layoff. No one is required to continue to make themselves available for a job that doesn't provide them with hours and wages. So the first time you're laid off, from the first day of your layoff, you can say, this is a layoff. I'm not accepting it. I'm treating that as a constructive dismissal, and I'm asking you, employer, to pay out my severance. So that's what happens when you're laid off for the first time. Even if you don't protest, at some point, the layoff becomes a termination and you're owed severance. All right. So ball's in your sister's court what she wants to do about this. But if she has any more questions or wants to pursue her severance, then reach out to us. That's employmentlawyers.ca is our website. Employmentlawyers.ca. We'll be happy to help explain to her what her entitlements are, what she can do moving forward. And so that's the difference between a layoff and a termination. A lot of people use the terms as the same thing, but a layoff is actually legally, it's different than a termination. We have a question here from Ev Maurer. How soon after termination should I expect a lawyer to send a letter of demand? Well, you want to reach out to a lawyer as soon as you've been terminated. Sometimes the employers will say, well, listen, here's our severance proposal to you. Let us know if you're accepting the severance proposal by signing these documents, and we're giving you a week to sign. All right. So, now, if you do sign that document, especially if you see a document called a release in there, then once you sign that and return it to the employer, yes, they're going to pay you what they offered you, but you can't, you've signed away your right to sue them, so you can't get a lawyer. So very important that you try to reach out to a lawyer as soon as possible to have your termination documents reviewed. Generally, once you've spoken with the lawyer, you and the lawyer, if you agree to work together, will sign a retainer agreement, a contract to work together, and thereafter, 1 or 2 weeks after, the letter goes out to the other side, to the employer, explaining what in our case we would say what we think your severance entitlements should be. All right. So that whole process usually can take 2 to 3 weeks. The week it takes you to call us and set up your appointment, and the 1 to 2 weeks to open your matter and send off a letter. We have a question from Marcus on Facebook. Is it worth speaking to a lawyer if I've only been employed for 2 years and I'm now being let go? I'm 47 and work as a shift manager. So the thing that a lot of people, especially even people that visit our show, believe that at best severance is about a month per year of service. There are actually quite a few situations where people are entitled to more than a month per year of service. Surprisingly, it's the shorter term employees that are entitled to more. So Marcus here, if we were using that 1 month per year of service yardstick, Marcus would only be entitled to 2 months of severance, right? The reality is, we all know it's going to take just about anyone in any situation at least 2 months to find a new job. Between the time that you send out your resume, go to the interview, second interview, reference checks, review the new employment contract, get your first shift, first day at work, easily 2 months. If not, and that's if everything goes great, that's stupendous. If it takes you a couple of tries, if you have to apply for several jobs, it's easily 3 or 4 months before you find a new job. And judges are conscientious of that. So essentially, shorter term employees, especially ones in managerial roles, as Marcus is, will be entitled probably to a lot more than 2 months of severance. So yes, Marcus, I think it is worth you speaking with us to see what your entitlements would be. You can actually check for yourself what your entitlements would be. We have a severance pay calculator. It's free of charge. It's available online. You go to pocketemploymentlawyer.ca. You have the URL here on the screen. That's pocketemploymentlawyer.ca. We're going to ask you 4 questions, which are your age, your length of service, the type of job that you had, and your income. All right. You don't have to associate your name or anything like that with it. It's free of charge. Take a look. It's going to tell you what your entitlements would be. All right. And basically, once you know what your entitlements would be, if that's something that you want to pursue, set up a call with us. Absolutely. We'd love to chat with you and discuss to you how we get you your fair severance. All right. So absolutely. It's important that you reach out to a lawyer. All right, we have a question from Pamela Warren. I'm wondering if getting a booster for COVID-19 and taking the day off with notice to get it and deal with side effect is protected by IDEL regulation. So I live in Ontario. Yes, so there is a leave to get a booster shot. Absolutely. There's also 3 sick days, paid sick days that have been provided through the IDEL regulation. So for those who don't know, IDEL stands for Infectious Disease Emergency Leave. So it provides for 3 paid sick days through WSIB, which is workers' compensation, and provides for time off to get the vaccine. Absolutely. Absolutely. So yeah, all you really have to do is tell your doctor, your employer, listen, I have this appointment. I'm going to take the day off as a sick day to deal with any side effects, and then I'll be in the next day. It shouldn't be a problem. If there is any issues with it, then the best thing to do is contact the Ministry of Labor. Tell the ministry, listen, I tried to get a day off here so I can get my booster. My employer is refusing. Can you tell my employer to let me go get my booster? Ministry of Labor will be happy to help. They help enforce the IDEL, the Infectious Disease Emergency Leave. We got a question from Jonathan on Facebook. My employer is asking me to resign before the end of my contract, but I still have 4 months to go before my contract ends. Can they force me to resign? So absolutely not. All right, Jonathan, no one can force you to resign. All right, if they're forcing you to resign, it's because they're terminating you, and you can pursue your severance entitlements with them. All right. So basically, what I would tell the employer, I've seen this a lot of times. Someone will say, well, listen, I'm going to change your employment contract. I'm going to cut your wages by 25%. All right. And you tell them, no, I'm not okay with that. And they'll say, well, if you don't accept it, it's going to be a deemed resignation. It's as though you're resigning, right? That's absolutely false. That's not a deemed resignation. That's a constructive dismissal. All right. So you can tell them, listen, I'm happy to continue working here. I took this job because I wanted to work till the end of the term, which is in 4 months. if you want me to stop working now, you have to pay me the remainder of those 4 months. And even if you do that, Jonathan, I would speak to us first, because there's a lot of people out there that are on contracts every year, right? So you get hired, for instance, you work at a golf course or you work in a school, you get hired for the school year or for the golf season, then you go on EI, then you come back the next year, right? Some people, those are theoretically fixed term contracts, but you've been doing them for years, right? In that case, you might be entitled to a lot more than just the remainder of the contract. Depending on how long you worked there, the kind of job that you had, you could be entitled up to 24 months of severance. So that varies from person to person. But I'm trying to tell you is that even if it's only 4 months, that's probably a lot of money on the line. And even it could be potentially up to 2 years, depending how long you've been working there. So it makes sense to reach out to a lawyer. It makes sense to reach out to a lawyer, to have a consultation, to see what your entitlements actually might be. Employers do, I mean, some of them don't know the law any better than you do, frankly, but most of them are giving you incorrect information when it comes to the law. You want to hear it from someone who's on your side and who has a legal background. So that's where you want to reach out to us and speak to an employment lawyer who's on your side to tell you what your severance entitlements might be. We have another question from Hamburger93. How can the company that let me go for not being vaccinated last November still to this day continue to make any future new employees be vaccinated? Non-union, of course. All right. So if I understand what you're saying, so basically, Hamburger, what I'm understanding what you're saying is that your employer instituted a vaccine policy, terminated the employees who refused to get vaccinated, and required new hires to be vaccinated. All right. So speaking just of your term, which is your termination for being unvaccinated, it's likely that you have a claim for severance there. You want to reach out to us so we can discuss with you your severance entitlements. A lot of employers are terminating employees without severance, alleging that the fact that they didn't comply with the vaccine policy is grounds for dismissal for just cause, in which case you're not entitled to severance. You have the right to have a judge determine whether there actually was just cause to terminate you. And if there wasn't just cause, the judge is going to order that the employer pay you your severance, including potentially even other damages as well, such as punitive wrongful dismissal, punitive damages, sometimes human rights damages. We're seeing a lot of people who are being terminated or placed on leave for not being vaccinated. These people put in a religious or medical exemption request. It was not well treated by the employer. The employer didn't really consider whether they had a valid exemption. They wanted a uniform policy for everyone. The fact is that human rights requires a particularized assessment of each individual. If your blanket policy violates the human rights of one person, then that's a violation of their human rights. There's no other way of viewing it, right? So I know that everyone wants to have easy to enforce, easy to understand blanket policies, but that oftentimes runs afoul of human rights. So definitely reach out to us. With respect to requiring requiring new hires, the reality, unfortunately, is that employers can list whatever hiring criteria they want. They might want someone with a certain diploma, certain years of experience, a certain vax status, and that's legal so long as it's again not a violation of that person's human rights. So if that person can't get a vaccine because of religious or medical grounds, then the employer that has a duty to accommodate them through the interview process and to consider their application, even though they're in non-compliance with the policy. But if there isn't really a human rights or a human rights ground why that applicant can't take the vaccine, the employer is entitled to require new hires to be vaccinated. All right, so where am I here? Bear with me a second. Hamburger, there we go. Question from Jonathan. My employer is asking me to resign. It's the same question as before. So Carrie's asking, so why do employers often say you're only entitled to 1 week of severance per year of service? So employers, like I said, don't often know the law, all right? So you can have a judge determine how much severance you're entitled to, all right? And a judge is going to look at what's reasonable And a judge is, in the vicinity of about a month per year of service. That's in that range, a lot more than a week per year of service. However, in each province, there's an Employment Standards Act or an Employment Standards Code. It's a law that governs work. It's a law that talks about minimum wage, overtime pay, vacation pay, and it sets out certain minimum entitlements that every employee has if they're terminated. Now, I want to emphasize that minimum is precisely that. It's a minimum. Generally, a judge will not give you just the minimum. Generally, a judge will give you what they think is reasonable. All right, and so most of our files where we reach a settlement or go to trial, we get our clients severance that is reasonable, not the minimum severance that they're entitled to. Okay, but sometimes the employers, all they know is about this Employment Standards Act or this Employment Standards Code. They go and look on the Ministry of Labor website. It says, it's a week per year of service up to a maximum of 8 weeks. They pay that. They think they're golden. In fact, they're not golden. All right. They have substantially more entitlements. They should have consulted a lawyer before they terminated you. They probably expected you not to consult a lawyer, but you did. And now you know that you have severance entitlements that can be many multiples of what they originally offered you. It can be as much as 24 months of severance. So all of you know that's a lot of money. It's worth reaching out to a lawyer and having a consultation. I have a question here from Great Tesoros. I asked for an accommodation for family status. The company declined, said all employees are to be in the office same number of days. No investigation as to my family need. Possible discrimination. Absolutely, that's a possible discrimination. When you ask for an accommodation, basically the employers has to engage in an accommodation process, which is to assess your restrictions, even family status restrictions. You might say, well, listen, there's no daycare. I have to care for my kids. Like they're learning remotely. Someone has to be there in the house to watch them. They're very young. I can't be in the office. I can work from home and keep an eye on them, but I can't be in the office. The employer's going to say, well, I don't care about your kids. You have to be in the office just like everyone else. And like I said, there is, again, a blanket policy that isn't customized and individualized to each employee's human right needs, right? Your employer has a duty to accommodate you, all right? So you can have the employer, you can bring you can ask our help to bring a complaint to the Human Rights Commission and potentially to the Human Rights Tribunal to have your employer engage in the accommodation process as they're required to do. So again, like all accommodation, like all human rights cases, we need to know the facts. They're all very fact specific, but generally the law is if you have a restriction, be it due to your religion, your medical status, your family status, your employer generally has an obligation to accommodate you, all right? And so basically they have to, at the very minimum, engage in the accommodation process. Ask themselves how they can accommodate you. What needs to happen for them to be able to accommodate you? It might be that at the end they say, well, we can't accommodate you. It's impossible to accommodate you. I think that would be doubtful in this case. If you've been working from home for the last 2 years, why can't you continue to work from home? It doesn't seem like that would cause undue hardship. But every case is different. We have to see what the employer is saying. Great Tesoros followed up. Currently, it's hybrid, 4 days at home and 1 in the office. Company says 4 days is enough to allow employees to have a balanced schedule. Well, balanced schedule is fine. I mean, you have your kids 7 days a week, I suspect, right? I mean, we don't, not a lot of part-time parents out there. These kids need to be cared for 7 days a week. All right. So if you need to care for them during the 5 weekdays and there's no other option but for you to care for them, then your employer has a duty to accommodate you. All right. So that's just the way it is. All right. There's no part-time parenting. You can't just leave your kids home alone. Right. If there are other options, you have to consider. If there's daycare, if you can leave them with a family member for the day, you have to consider that too. But if there really isn't any options, then it's your employer's duty to accommodate you. We have time for one last question. We have a question here from Aaliyah on Facebook. My employer is selling the business and we do not know if the new owners will be keeping us on. We've been giving 2 months notice. Are we owed any severance if the new employer doesn't keep us on? Absolutely, absolutely, Aaliyah. Basically, if your employer doesn't keep you, the new owner doesn't keep you on, you've been terminated. You're owed severance. Before you accept 2 months or any kind of severance proposal by your employer, by your former employer, it's important that you make sure you're not signing anything. You want to have anything that you're required to sign reviewed by a lawyer. Okay. Because you don't want to sign away your right to go after your former employer, right? So make sure to reach out to us. We can review your termination letter and all of that. And yeah, absolutely, you might be entitled to more. I say might, not because there's a debate as to whether you're owed severance, but there might be a debate as to whether 2 months is sufficient notice or not. To find out how much notice you're entitled to, again, visit our website, pocketemploymentlawyer.ca. 4 quick questions, and you'll find out how much severance you're entitled to, and we'll help you go after that. All right. So reach out to us, pocketemploymentlawyer.ca, to find out how much severance you're entitled to. My name is Lluc Cerda. I'm Senior Associate here in Calgary of our Calgary office of Samfiru, Tumarkin, LLP. We're employment lawyers and disability lawyers. We're here to help you go after your rightful entitlements in your job or when you're terminated. Feel free to reach out. And we have more shows. If we didn't get to your question this week, feel free to reach out. We have shows like this every day this week. We're here waiting to hear your questions. Thanks for tuning in. And until next time.